most people.
Yes.
And basically, the judge was almost saying directly that it's going to affect private property.
Oh, the decision affected private property rights immediately within the area that title was declared. But we can't forget that the court also, and for your viewers, I'll throw out a paragraph number, which by itself I think speaks volumes. Paragraph 3,551, the last sentence of that paragraph, where the judge writes, a precedent that will flow from this case is that sections 23 and 25 of the Land Title Act do not apply to Aboriginal title.
So
that's a verbatim quote.
So for us who are not lawyers, what does that mean?
Well, section 23, and you'll see companion provisions in all the provinces and territories in Canada and in the common law world. Section 23 lays out the rights that a private landowner has with their land. And these are akin to exclusive rights, subject only to the Crown. Section 25 is all the protections the Crown affords those rights. So, to put it a bit more bluntly, it is the heart and soul of fee simple property rights. The court said a precedent that will flow from this decision throughout all of BC, in this particular judge's view, is that those two provisions don't apply to land where Aboriginal title has been declared. So I've seen some things in the media about sort of fear-mongering and, well, it didn't quite go that far. Paragraph 3551 is an absolute express statement of what the court was saying. And so it's not just Richmond. It is very clearly directed towards all fee simple property in British Columbia.
Fee simple being
privately owned, whether it's owned by Indigenous people or non-Indigenous people.
That's an important point to make, that it wasn't just about a strip of land in Richmond. This decision affects private property everywhere.
Yes, I mean, the court could have restricted their reasons strictly to what is going on the Richmond land. And even that is worthy of discussion because there's some challenges on its face with the decision. But the court was very clear that no, this was intended to be a much broader application. And again, very clearly in black and white, the judge wrote what she wrote.
Were you shocked?
Yes, I think on its face. I mean, looking at the guidance from the Supreme Court of Canada on justifiable infringement, I believe, it might have been the last time I saw you, but paragraph 165 of Delgamuuk, one of the few paragraphs the court in Chilcotin lifted expressly, talks about the list of justifiable infringements to title being, quote, fairly broad. And then it lists a whole number of examples of what fairly broad looks like: forestry, mining, the settlement of foreign populations, which is, of course, homesteading, environmental protection, public interest concerns. And the reason, in my view, that the court said it was fairly broad is that if it wasn't, it wouldn't allow governments to govern, and especially in a province like British Columbia, where we have over 200 First Nations, all claiming or who have claimed title in some form or another. So if you had absolute title, you would have no room for anyone else to exercise any governmental authority.
And it seemed that the decision said that Aboriginal title is the senior interest, above government, above private property.
You are quoting verbatim, I believe. Yes, that's right. A senior interest in land. Again, with due respect to the court, that isn't how the Supreme Court of Canada described Aboriginal title, in my view. The Supreme Court of Canada, in numerous of its decisions, talked about Aboriginal title being a right to the land itself, not an interest in land. And for the non-lawyers, there's a big distinction, because once you start talking about an interest in land, all the normal rules around land apply. But that isn't the case with Aboriginal title. Many people will have heard the phrase sui generis, or unique. It's a unique element of land, a unique right to land. But it is a substantive right. But it's not like fee simple. They're similar in the sense that they're both exclusive rights to land. So there are similarities, but at their core, they are two fundamentally different sets of rights. One flows directly from the Crown, which is your fee simple rights to your viewers who own land. That is your title in sections 23 and 25 of the Land Title Act, which the court threw out. First Nations get Aboriginal title as a result of their prior occupation of Canada. And the balancing between the two, the only tool the government has, is justifying infringements to title.
So you weren't the only one who was shocked. I think most people who read it at all carefully, does this really mean what it says? And one of the individuals was Premier Eby, because Premier Eby, with HIDA and other issues around the province, has said, doesn't affect property rights, doesn't affect property rights. Everybody be calm. He immediately, I think it was within that day, joined the appeal of this decision, saying, that's not what we'd intended.
Yeah, I mean, look, it was good. We did a little legal update on the decision when it came out, and it was nice to be able to quote Premier Eby for the first time in my career, talking about the interests of mortgagors and investors, again, whether they're Indigenous or non-Indigenous. We want to welcome capital to our great province, not scare it away. Having said that, Between the Cowichan decision coming down and the need for the province to file its appeal, the EB government slipped into court and filed its Haida Nation order, which on its face may look like they're similar. They're fundamentally opposed, because remember, the court in Cowichan said sections 23 and 25 don't apply to Aboriginal title. The Haida agreement says provincial legislation will continue to apply on Aboriginal title lands. I'll leave it to your viewers to try to reconcile those 2 points. The second point is...
Okay, so I'm just going to stop sharing that at the moment so we can take everyone back here. And just so you can see that this is the information that generally has been regarded as fairly accurate in its assessment. And then, of course, I apologise for the late recording on that. Like I mentioned, we are a little bit green coming back into doing these Zooms again. So thank you for your patience. And with that, I will definitely be sharing this video and recording. And I did introduce Lloyd with KCSA as being our president. And he will be going a little further afield to what he's done and obviously the issues surrounding the issues of Undrip and Dripa and how it's imparted into ACT in BC. So Lloyd, after you, my love.
Thanks very much, Tracy, and thanks everybody for coming out to this Zoom. It's a really good start to the year, and I think it's going to be a really interesting year coming up. So part of what I wanted to speak about is that you got a good idea of what was sort of the issue with respect to Mr. Issac and how he put it forward, and so I'm going to talk about that for a bit, and I'm going to also ask for some comments from David Lindsay, and then what I'm going to do is I'm going to move into why are we doing this, and what kind of campaign that we're looking to put forward on this particular issue. But anyway, to start is that it's very clear that that what's going on here are 2 different processes, and the last aspect of what the lawyer or what the fellow said there was that they went in and signed an order to solidify the agreement that they reached with Haida, and so that one aspect about provincial law applying on those lands is one aspect of the Haida agreement. The other aspect is that the Crown land that was the Crown land there transferred over to the Haida, but the freehold land in the city or in any freehold land, whether native or indigenous or non, remained freehold, so outside of that system. So what we've got, and then when you go through the treaty process, of which there are currently 7 finalized treaties and 3 or 4 in the process, then its freehold lands are not on the table. There's potentially a negotiation for those on the side afterwards, but they're not on the table. And so anyway, what this has done overall, this Cowichan decision, is that it's throwing, especially the way it was worded, as was said in the video about the senior right on the land, and then also the difference between the right to the land and the interest of the land, as was pointed out. But that what it's doing is creating, and especially in the Cowichan Richmond case, where we had, and I think Tamara has a story about this as well, but where investment is being lost from that area, people are having problems renegotiating their mortgage, and it's very clear that this is happening. As to what the extent is, we don't know, but the government is backing, saying they have money to back any problems with people that are having, I guess, securing their mortgage or whatever that may entail. So anyway, we know that's a problem, and so the concern here, and one of the main asks that we've asked government through our letters, which I said we will get into, is that we want DRIPA repealed. And the reason why that we want that is that what DRIPA does is that it requires that all acts within the province of BC come in line with the DRIPA Act, the Declaration on the Rights of Indigenous Peoples Act, which is simply the declaration, the UN declaration being codified within an act. So then all the other acts have to come in line. So, and one of the recent decisions, and I don't know if I pronounce it right, but it's the Get Acts Aila mineral tenure rights decision where they part of the decision was the fact that it wasn't respecting those rights that are promised under DRIPA, and therefore it was inconsistent. And as a result, EB said, "Well, we may amend the act." And again, that's the danger. They amend the act. It means that it's still online, and it's still one of the problems with getting security on the land base. And anyway, so part of the that uncertainty eventually will affect the real estate market. It will affect the economy once that continues on. And the problem, and I guess one of the things, and I'm going to segue to David in a second here, but is that we want to create a situation where we have strategic litigation. So we want to be able to look at this in a way that how where these appeals are going on, they're going, and it's going to take time for them. But other decisions may come down with respect to this, but we want to make sure that we're on this and we're tracking it so that from a litigation perspective, we can step in and do something if need be to ensure that our rights are actually protected. But anyway, I'd like to introduce David and just get his take on this. And David Lindsay, if you don't know him, he's a strong advocate for freedom, and he's argued and put together many cases over the decades on different issues. But in particular, he has a good handle on what's going on, and I value his sort of opinion on this. And so anyway, David, what's your take on what's come down as far as it relates to the issue we're talking about here today?
Well, excuse me, thanks. As usual, I think it's important to go back to the beginning. And if you want to go back to the beginning, the first thing that I have a problem with is Canada joining the UN in the first place. Essentially, what is happening today is we are letting an unelected body take over our own country and our own lands and our own form of government. And we don't vote for the UN. They could come up with an agreement as they've done on this on Undrip, and suddenly it's incorporated as a policy into our own law. And our common law does not recognize any other form of law other than the common law. And this is one of the reasons England fought so hard not to get into the UN, because they knew as soon as they did, the UN would be telling and imposing their civil law in the UN or in the European Union, I'm sorry, upon them. And that's the same reason they eventually voted to get out of it. So it's the same with the UN. We need to get out. It's not enough to simply say we have to repeal DRIPA. We need to get out of the UN and have them stop telling us what to do. We're an old enough and mature enough country that we can make our own decisions. We can make our own contracts with other governments and our own agreements. We don't need an elected body based on law that is not even ours telling us what to do in our own land. I have a problem with the decision in the Cowichan case, in the sense that both the judge and the government were talking behind the scenes. David Eby admits that the judges were talking to him and telling him what was going to happen in the case. And my first result was wow, here, what happened to the independence of the judiciary when the judges and the government are talking about the case behind the scenes? That's not supposed to happen if they're independent. So you've got that happening, and then you've got the fact that the government and the judges agreed that the landowners would be given no representation in the hearing. This was a 15-year or 10-year case, and 500 days in court, and the landowners at stake were given no notification of this, and yet constitutionally it's their rights that are affected by it. And I'm concerned that they were given no notification, and decisions were made that are going to affect their property interests in the land. And then there's the recent class action case that has been filed against the government by various landowners. That's not a good idea either. And I guess this all goes back to the lawyers. I think the lawyers are intentionally on the government side. These lawyers that were in the case, 500 days in court. How many hundreds of millions of dollars did these lawyers make? It boggles the mind. And now they want to do a class action. And as one lawyer told me years ago, who was on our side, the last thing you want to do is a class action, because the courts look at it as that's it. It determines it for everybody. And then everybody is screwed after that if evidence doesn't get on the record, or if things happen, that errors happen or arguments don't get on the record, you can't raise them again. So I would rather see 25 or 50 or 100 landowners simply join together on a claim. And then that way, if there's errors made, somebody else can come up the food chain right afterwards and file their own claim and correct it with new evidence and arguments. The idea of filing class action suits is going to cause problems in the long run as well. So my take is that this has been a setup from the beginning to get all the wealth and minerals out of our land. Why didn't the Indians, somebody raised this in Cowichan, why didn't the Indians raise this case 80, 90 years ago? Why was it only raised now when the land is worth hundreds of billions of dollars and everything's on there and the amount of money that they can get is probably immeasurable? Why are they only doing it now? And I submit they waived any rights that they had. And I go back finally on my last point, as I pointed out in the text, Indians were never here first, and they were never a nation. They have no claim to the land. As one Indian said, who was on our side, ironically, a few months ago, he said, just because my grandfathers and forefathers walked this land 500 years ago doesn't mean they own the land. They had no concept of land ownership. They were fighting with other Indians and warring with each other, and then they would move if the weather got bad or moved if whatever happened. They did not have a concept of land ownership. And for them to come into court today and say, our forefathers told us that we own the land, and then suddenly all our rights are extinguished, is fundamentally wrong. And Delman Butte has to get attacked from the Supreme Court of Canada as well. And, on one final note, the Crown is required to protect us under the Constitution in our property rights. And that goes back to their coronation oath. They swore to protect us in our property rights, and they're not doing that. And they have, the Crown and the lawyers have violated the Constitution on that basis. So it's a complex weave of issues that are ongoing right now. I think the lawyers are on the take. I think the judges are on the take. And I think the government's on the take. And how do you get around that? It's going to be very difficult when all three levels are compromised. It's going to be very, very difficult because people are not going to give up their land and all their investments for 100 years and just walk away from it. I don't think that's going to happen.
Well, thanks, David, for that synopsis. And I think it's a very complicated issue and one that stirs a lot of emotion. But I guess overall, what we're looking for is fairness and balance of interest across the land base. And I think that when we look at whether it's myself as a homeowner or anyone, homeowner, renter, or whatever, that we need to have that kind of certainty on the land base and not, I guess, in fact, continuing to pay for First Nations litigation against us as the citizens of the province. But it doesn't sound like that it's going to be a hard stretch to go to win this and to change it. So I guess the way I look at it is that we are trying to change it, and the only way that we can change it is to raise a stir about it, to get people more knowledgeable about what's actually potentially can happen, to get the politicians activated, to start talking about it and doing something about it. I mean, the Conservatives have talked about repealing Dripa and that, but I don't care which government it is. It's like, where is the action on it? What are you doing about it? Or are you really talking about it? That kind of stuff. So I think so one of the things that we've done here is to set up a campaign, and this is just the beginning of it, which is to get that kind of interest in the issue forward to our MLAs, forward to our premier, the opposition, and basically the politicians, that this is an issue and we want it dealt with, and we want it to be dealt with now. And this obviously will focus in as far as an election issue. But a lot of times, and I can tell you from all the years of advocacy, that when you're in these battles, it doesn't seem like you're going to win them, and that you're basically, it's hopeless. So I'm just going to give you an example of cases that I dealt with decades ago, and that was about the South Chilcotin Mountain Park So since 1937, people have been trying to create a park in that area. And can you put up the picture of it, Tracy? And anyway, they've tried to. We're trying to. So we were trying to create a park there, and Tecominco and the mining interest had wanted that land for mining, and that was extremely important to them. So anyway, what happened was is that we ran a campaign, and what we did was that we spent about $35,000 and ran a quarter-page ad in the Globe and Mail business section against Tecominco, against the other companies that were planning on basically going in and destroying this pristine area in the South Chilcotins. So anyway, that ad was about how you could, to phone Tecominco, to fax them, to email them, to do all this kind of stuff. And had been in contact with their lawyer and told them beforehand, we're going to do this. You guys going to change your position. And he said, no, they're not doing it. So I phoned him up. I guess the day that the ad dropped, and he told me, and I talked to him the next day as well, and he confirmed the fact that Tecominco's fax lines were jammed, their phone lines were jammed. They had to communicate in alternative manners because, and the letters that started coming in, and that was just incredible from having this ad running across the entire country. So it showed there that and it wasn't just the ad. There were a lot of other aspects that went into this, which all campaigns have. And it's not one person, it's a whole bunch of people that end up doing this. Anyway, the end up result is they agreed to remove all their mineral leases, and we created the park. And again, that just shows that you can do that. So what we've done here then is to start the campaign off with letters to the MLAs, to the Premier, and to the municipalities, informing them of the issues and asking them to act on it. So, and then again, these letters are up on the website. They're downloadable, and they can be emailed, and that's what we want to see happening is the emailing of them out by various groups so that we get as much coverage and people, whether they're an average person that wants to send a generic letter, an organization that wants to send a letter, regardless, that's what we're looking to do. And we can get into that when we go through the website and show you what we've got there. But this is just, as we said at the beginning, and I guess the other thing that we're looking for as far as what we want to get out of this is we want to get more people actively involved. We want people helping out with the campaign, taking on different aspects. It takes a lot of different little things to actually make things happen. So we're looking to build that up. We will be launching a campaign within the next 2 weeks as well on municipal councils, and it's entitled the Government Integrity Program. So that again is a different issue, but it is to hold municipal councils accountable to the public and the right of the public to be able to speak to their councils and not be made. It's not, and it's illegal by law for us to do that now. So anyway, that's just another issue. But coming back to what we're trying to achieve overall is we're just trying to achieve, more people's interest in this, and because there's a real concern that the EB government will not act in our best interest and will not argue the case or the appeal, strongly. So this is just to get a jump on things and start things off. So I think I'll just leave it there because we can talk about those other things and leave time for questions and move on to Tamara's presentations, and has a really good handle on what's coming down, and I really appreciate her advice in this area, and I'm sure you all will as well. Tracy, did you want to take it now?
Thanks.
A passionate BC resident and 26 years in the business in BC, not just in Kelowna, but across other parts of the province as well. So without further ado, Tamara, would you like to come and give your presentation on the aspects through the lens of a realtor and a homeowner?
Absolutely. And I'm so happy to see so many people here because this is really important stuff. The reason I'm speaking tonight is as a realtor, I've been with Remax Kelowna for 26 years. I've lived in BC my entire life. I own property, I have investment property. I've also lived on Haida Gwaii, and I'm familiar with the Haida Gwaii land agreement. I've talked with people who are Haida who are supposed to receive money, so we'll just leave that there. I've had conversations with people who operated businesses on Haida Gwaii and actually were not forced to move their businesses, but saw the writing on the wall and made the decision to move their business out of Haida Gwaii. So that's kind of an interesting aspect as well. So I'm talking with people all of the time. So I'm bringing this down. I'll speak about the actual real estate because I think a lot of people don't understand what fee simple is. So basically as a background to the land title system in BC, so I'll start with a Torrens system. It's a title registration system where ownership is proven by registration, not by possession of historical deeds. The land title register is definitive. What's on title, your title search when you buy a property is legally correct. In BC, this system is governed by the Land Titles Act, which is in Kamloops, and administered by the Land Title and Survey Authority of BC, known as the LTSA, is the abbreviation. This is the system we've relied on, and that's provided a comfort and a level of certainty for owning real estate in BC. So fee simple, or we call freehold ownership land, opposed to leasehold land, is the highest and most complete form of private land ownership in BC. Just give me a second here. When you own land in fee simple, you generally own the land itself, any buildings and improvements on it, and the right to occupy and use the land, sell or transfer the property, mortgage the property, rent or lease it, leave it to heirs in a will, renovate, build, subject to laws and permits. However, fee simple does not mean absolute ownership. Many people believe it's absolute. So the limitations on fee simple in BC are subject to government authority. So i.e. if there's zoning bylaws, building codes, development permits, property taxes and expropriation with compensation, also registered charges on title, strata fee simple, Indigenous rights and title, the municipal and environmental restrictions. So the benefits of fee simple versus leasehold is that the ownership is perpetual. You're the registered owner. You have full mortgage options. You have resale ability. The resale is generally higher and the control is greater than leasehold property. So the concern with Justin Barbara Young's ruling in the Cowichan case over Richmond lands in August this year is that the court ruled that historic Crown grants of fee simple land titles to the government and third parties, including Richmond, unjustifiably infringe the Cowichan's Aboriginal title. The decision confirmed that BC's Land Title Act does not protect private property titles from Aboriginal title challenges because Aboriginal title exists outside the land title system and it's constitutionally protected. Why it matters is that this case is unusual because it deals with urban Aboriginal title over city lands, not remote or treaty settled territories. It raises important questions about how Aboriginal title intersects with existing land titles, government's obligations to negotiate in good faith, and the future framework for Indigenous land claims in Canada. So legal experts note the decision does not automatically invalidate private property owners' titles. Rather, it directs governments to negotiate how Aboriginal title and existing fee simple titles will be reconciled. We keep hearing that word, reconciled. Every time I hear reconcile, I think money. So who's paying who? Potentially through compensation, shared arrangements, or other negotiated solutions without outright dispossession. So here the problem with Justice Young's ruling, she stated that fee simple and Aboriginal title can coexist. But it's incoherent. Now that word is from Bruce Party. He explained it quite well because fee simple in itself is an exclusive right to possession. So you own your home, you own the land, you can live there. But Aboriginal title also has a right to use, have possession. Then fee simple is not an exclusive use if Aboriginal title is also an exclusive use. It becomes some form of joint use. That we don't know what Justice Young was how she was expecting this to roll out. But this is where the confusion comes in. So this would obviously need to be clarified. There is an appeal, I think, as most of us know, for Justice Young's ruling from the Supreme Court. I think now it's about approximately maybe 12 to 14 months, which could provide certainty that BC property owners and business owners need. But in the meantime, property owners and business owners have concerns about the details of reconciliation in areas that affect all of us, specifically pertaining to any potential costs to the property owners. What will this cost us? Do we have to pay extra property taxes? Who do we pay property taxes to? What happens with utilities and utility upgrades? I'll explain that in a little bit. So, basically, it makes things confusing. It challenges the municipalities when they're providing planning and services to our communities in light of having to consult with Indigenous peoples before making decisions. The Cowichan Court decision leaves more questions than answers, and Dripa, BC's Declaration of the Rights of Indigenous Peoples Act, in itself, it has too many ambiguous terms, which then creates uncertainty. So in real estate, when we have contracts, we can't have ambiguity. We have to have clear, definitive terms. So everybody knows who's doing what. Now, we also have, so as realtors, we need a reliable source to perform our due diligence for our clients. We need to find out if private properties have active Aboriginal claims. Where do we go to find this out? Is this source reliable? Are there overlapping claims? We also need a reliable source to find out which properties are in archaeological sensitive areas. I don't know who's aware of the Heritage Conservation Act amendments, but I was on as a stakeholder. And the biggest problem I see is that these negotiations were happening, in secret, between the government and the Aboriginal councils. The public that would be affected by the cost, to enact these amendments were kept in the dark. So an example that was given, there's an arrowhead that's found in your backyard. And so now it's deemed an archaeological sensitive area. Well, then whose cost is it to excavate your backyard? Say you have a nice pool, you've spent $100,000 in landscaping. Who's paying for that? And then if there's no arrowhead, who pays for the damages that this has now caused, for your backyard? So, these are all questions that were coming up in this meeting where they're wanting to make these amendments. And the biggest concern I have with these things as a homeowner and as a realtor is that there's an idea of this liability now as the homeowner that, we as homeowners ought to have known if we're in an archaeological sensitive area. Well, where's our reliable source to go to confirm these things? So the issue I have, and one of my solutions, is that in this presentation tonight, that we're all aware of some of these things that are happening in the background that affect our property. We know what the problem is. We can identify it. We can bring it up with the people that we need to, our MLAs, our MPs. So continuing on, so now let's bring this back to how this is affecting the real estate market. So just let me get back where I was. So the real estate market is affected by perceptions of uncertainty. So as concerned citizens, right now we're brainstorming for solutions. We want to improve, we want to improve the lives of people that, so-called, the Indigenous people who don't have economic stability. Yes, I believe everybody should have a fair right to clean water. They should be able to own land. So those are some separate topics and separate issues. I don't think that this vehicle called Dripa is achieving what they're telling the public that it's achieving. And I actually have some anecdotal evidence that some of the people that it's supposed to be benefiting are not receiving any funds at all. And it's not improving their way of life. So that's where the problem comes in. This is where we need to work on some solutions with this. I've been doing my own research. So I personally had to renew my mortgage on my property. I have actually 2 properties. So one I just renewed. I talked to Beam Credit Union and I asked them, I said, as a realtor, as a property owner, do I have anything to be concerned about to renew my mortgage with these land claims that were happening in Richmond, but with some of the results of Justice Young's ruling about this coexistence of Aboriginal title. So even though Kelowna, it doesn't have an active claim that I'm aware of, I wanted to be proactive and ask these questions, just to see if if the banks and the credit unions are thinking about these things. I was told that this was not a concern right now. I didn't have a problem renewing. I just renewed my mortgage personally. But I did talk with a business owner in Richmond, and he has been affected by this. He personally was not able to renew. There's probably more things going on in the background that could affect that. That's commercial, it's not residential. So I'll try to stay in my lane and just speak about residential. One of the other calls that I made was to City of Kelowna, and I wanted to ask them, is there a spot that I can go as a property owner to find out if there's any land claims on my property? I have 2 properties that are fee simple, freehold. And they said, oh, well, we don't do that. You'd have to call land title's office. So I said, great, okay, I'll call land title's office. I talk with them all the time. I phone up land title's office, and land title's office said, whoa, we don't deal with that. And I said, well, if you don't deal with that, then as a property owner, how do I know if there's a pending claim? And they said, well, if there's any pending claims, there will be a notation on your title search. So I thought, okay, well, I'll dig deeper. So they had suggested, well, maybe you should go to the BC Treaty Commission. So I went to the BC Treaty Commission, I gave them a call, asked the same question. I said, I'm just curious as a property owner, where do we go to find out if there's any claims, pending claims? So there is a link to the resource. I think Tracy will post that for you. And in that link, so it sort of explains where there's the West Bank First Nations, and then there's, I don't have it right in front of me, but I believe it's here,
I'll get that up for you, Tam.
yeah, it was the Lower Nicola, the Penticton, and the Okanagan Nation Alliance. So I have made some calls to them. So I am doing research, and anything I find out, I'm happy to share with any of you if you're curious, interested. But what I could find out so far, there was a little map, and it showed what the outline of the West Bank First Nation area was. And so that did include more of Kelowna than I was aware of. So we want to be 100% sure that this information is correct. This website was fairly recent. So again, I have a call into them, and so I'll find out if there's any changes or updates to that. Okay, there's the map. So what we do know as realtors is that when we're dealing with West Bank First Nations land, we know what we're dealing with because they're self-governed. We understand the leases. We have lawyers that understand the leases. And so we know what we're dealing with. We'll call it certainty. The uncertainty now is with this latest ruling. So my goal is that we have some level of certainty. So if there are treaties, then we have a resource that we can go to that's reliable, and we know what's treaty land, what's not treaty land. That would be one of my suggestions. Moving forward, some of the other things that I can see that could be a problem is I have an uncle. He generously gave me a lot of time on the phone. In the 70s, he worked for City of Kamloops, and then he worked for Regional District. And so he did all the training that they put him through to work with the different tribes and the different bands. And he said, one of the biggest issues that we had is that he said we come to the table and we try to negotiate with them to get things done. But, if there's a water line that needs to be upgraded, he said it just takes forever to get a decision made. And so this is part of the problem. So, it's how do we get these decisions made? And then we've got our municipalities with their hands tied, because now every time they want to upgrade a sewer line or a water line, now, how many people are they speaking to? How do we make these decisions efficiently and effectively? And in the meantime, provide the services that we're all paying into, right, with our property taxes. So the other thing that I just thought I would bring up about the real estate market, I thought as a realtor, I've been doing this for almost 3 decades, that we would instantly see a massive increase in our listing inventory. So we always speak of supply and demand. So our supply, how many listings do we have? Demand, how many buyers are out there purchasing and able to do so? So, but it was interesting, our total listings. So in July, because our stats are done from the month prior, so we'll say June 2025 of this year, we had 4,419 listings total. And actually now our stats just came out for the completed month of December, and that went down to 3,149 listings. So now the list to sale ratio, that had actually gone down as well. So that's how many listings are actually selling. So back in the summer before this announcement in August, 12.67% of our total listings were selling. Now we've got 10.73% that are actually selling. So we are seeing some changes in the market, but we're not seeing the behavior that I thought that we would see right away. So, people are still buying and selling, but personally, I've had some buyers who've said, I just want to sit and wait to hear more. If I'm going to be, especially investors, we want to know what the outcome of this is going to be. Are we going to have any challenges with financing, commercial financing? What about tenancies? So these are some of the questions that are coming up. Our real estate board is not giving us a lot of guidance because they're saying, well, just defer to your lawyers. So the lawyers will know, or if there's uncertainty about whose land is fee simple or not, call your lawyer. So this seems to be the solution right now. Anybody have any questions for me just based on market effects that we've seen?
Feel free to unmute yourself if need be.
Tamara, could I just ask a quick question? Are you noticing like a downtrend from assessed value to what they're selling for?
Yes, we're starting to see some reductions in the appraised values. Assessed values won't come out until we'll know what that looks like by January, February, but appraisals are coming down. So, and we have seen a slight drop. Like I always refer to the median house price because it's the most broad, but it's the most common, most accurate of what's really happening. So that's gone from 895,000 is a median for a house, and that's gone it's gone actually from 919,750 to 895,000. So we are seeing some price reductions that are coming through.
I work in the same space as Tamara, but I do a little bit more on the commercial side. And I will tell you that a couple of transactions in particular, this actually came from the lawyer who was in that clip earlier, transactions in the tens of millions. Both those transactions collapsed as a result of the Richmond deal. So there is capital that is stopping and it is flowing outside of the province. Because capital can flow wherever it wants to go, and it's going to go to where the least amount of drag is, and they don't like uncertainty. And that might not relate to the everyday person, but when you have capital and investment that is making decisions and it's not investing in our province, that is not good for anyone. So it's just a general commentary on the commercial side of things.
Thank you, Shane. Yeah, it's accurate. That's where the flow starts, and then it affects residential.
Yeah. Thank you, Shane. That was very important knowledge. I know that in the chat we do have Kelly who is here with us. And Kelly, did you want to unmute and come on in?
So I've obviously I'm also in real estate myself. I've been doing this for 19 years, not quite as long as Tamara. Most of my time was spent in Alberta, relatively new to this market, last 4 years or so. But I've done just a ridiculous amount of research. I've seen that video that you showed probably 3 or 4 times. I've consulted with the Conservative Party of British Columbia. I was involved in their board. I was involved with John Rustad in his run. I got involved with One BC for the very short period of time that they were an actual registered party in the legislature, and I think there seems to be a lot of information floating around out there that isn't necessarily correct from my understanding. And this is essentially the question. Now, I think we can all agree that DRIPA needs to be repealed. In my opinion, it needs to go a little bit further than that. My opinion is that the Interpretations Act also needs to be repealed. With those two acts being repealed, however, that does not reverse the decision of Cowichan. It does not reverse the decision of the Gitz clan, or however you pronounce that decision that was just made, which incidentally, I believe the provincial government had until yesterday to launch their appeal on that decision, which I don't believe that they did. That's an aside. My understanding is that the only way that Cowichan gets reversed would be by constitutional amendment. Now, we were just having this discussion in the chat. Indigenous property rights are enshrined in the Canadian Constitution under Section 35. Private property rights for everybody else, are not enshrined in the Canadian Constitution. There's a statute that exists, I believe, that goes back to 1960, which essentially, like I said in the chat, it says private property. There is a non-constitutional statute that recognizes the right of the individual to enjoyment of the property and the right not to be deprived except by due process of law. I think that's somewhat up for interpretation. It's not as solid as Section 35 as it pertains to Indigenous property rights. So my question for the lawyers in the group, I think there might be only one that I heard of, would be this: if DRIPA gets repealed, the Interpretations Act gets repealed, Cowichan still exists, would the only then course of action, if Cowichan appeal goes through and is defeated, and Cowichan exists, setting the precedent, would the only way to reverse this would be through constitutional amendment? That is the question that I have.
I think Dave could probably chime in on this and help us there. Would you help out, please, Dave?
I think that if Cowichan is eventually upheld, again, I go back to what I said about the lawyers intentionally misrepresenting the case and not advancing the arguments they were supposed to do. I think the solution is to look to our own Constitution, which is much broader, as the Supreme Court of Canada ruled, than the Constitution Act of 82 or 67. The primary constitutional provisions are the rules of succession of the monarch, of the king. And that is the starting point for all powers to give royal assent. So when we talk about the DRIPA Act in BC, it was given royal assent by the Lieutenant Governor on behalf of the king. And if the king did not have the power, because it is a limited monarch, if they did not have the power to give royal assent to the DRIPA Act, and that's the starting point right at the beginning, did you have the power to give royal assent to it or not? It's a lot longer than I can get into here, but I just point out that property rights are in our Constitution. They're in the rules of succession of the king, and they swear an oath to uphold them. And I'm just grateful that that's where they are and not in the charter. Because if they were in the charter, they would have used Section 1 to override it a million times by now, and we'd have nothing left. So I don't think a constitutional amendment is required. I think it would be good to have it and have Section 35 removed. I think in 33 if it was. But we also have provisions within our own Constitution that should be relied upon. And going back to what a lawyer told me years ago, he said the problem is that these lawyers are paid by the governments to frame the case in a manner that's designed to get the results they want. So you look at the case that's been put to the court, and it may look good, but from a legal perspective, they are designed to get exactly the opposite decision, and the judges all know how it's worded. If I can give you just one quick example, I showed up at the Edmonton case for the firearms reference challenge years ago, and I got copies of every single factum and document filed by all the parties. And I talked to the lawyer, the King's Counsel, and the first day of trial at break in the morning. And I said, I read your notice of your challenge to the firearms legislation. And I said, why did you challenge it in this manner? Because I said, you're going to lose. And he said, why would I word it in a way that was designed to lose? He said, I'm getting paid to win. And I said, you're going to get your ass kicked. And I said, here's why, blah, blah, blah. And I forget now, we're talking 15, 20 years ago, but I said, I forget now, but I told him, this is why you're going to lose. You worded it this way, you worded it that way. And he looked at the document for 10 or 15 seconds. He threw it back on me, literally threw it at me, and refused to talk to me the rest of the week. And this is a fatal defect that nobody really considers or looks upon in the justice system, is these hearings that we don't get to take part of. When as I said earlier, even the landowners, they were never even given notification. And these lawyers filed the challenges in a manner that's designed to get this exact type of answer they wanted. And how do you overcome that aspect of it as well? It's going to be difficult in the long run. But yeah, Section 35 needs to be repealed in the Constitution Act, because the king's only duty is to his subjects. That's what the king swore an oath to. And it's not to the Indians, it's not to the Americans, it's not to South Africans or South Americans or the Chinese or anybody else. They swore an oath to uphold our law. And the judges have sworn an oath to the king to do that on the king's behalf. They're independent, but they don't have any more powers than the king has. And that's where we need to go. It's something that lawyers will not talk about because, as one lawyer told me years ago, he said, if we started arguing this, we would never win another case ever again. So they look at it from that perspective of financial. But in a long answer to your question, I hope that answered it.
No, it totally did. Thank you for that. It was very, very good. I'm curious then, who would take up the mantle of that court challenge? Would we rely upon the government of British Columbia to challenge the constitutionality of our own constitution as it relates to DRIPA and property rights? Or would this be a private entity of a conglomerate of concerned citizens that would get together to launch this with, various lawyers, etc.?
The government won't, unfortunately. I mean, they have sworn an oath to the king to aid and advise the king as well. And if they aid and advise the king in a manner that's wrong, they're not going to want to come back and admit they screwed up or they did it intentionally. I was working with somebody to get a lawyer last year to raise this issue properly before the courts. And unfortunately, the lawyer that we were talking with, after 4 months of negotiations, didn't work out. So we're now looking for another lawyer that we can properly get the right issue and get the right lawyer who believes in what we're doing. Because I spent 30 years researching this all over Canada. And I do have a lot of legal experience that I'm going to share with this lawyer. We just got to find one that's committed to what we're doing. So I'm going to be talking to a lawyer in the next week. I'm really disappointed 4 months worth of discussions got lost, but hopefully we'll make it up this year. But the government itself won't do it because they would admit that they screwed up. And they were, as I said earlier, what do you do when David Eby is talking to the judges behind the scenes? That's a major, major faux pas on his part.
Well, thank you so much, David. I appreciate that. And I hope, Kelly, that helped answer some of that information that you were sourcing and looking for there. Does anyone else have one more question that they want to ask before we move on to looking at some tools and where you can locate it and teaching you how to manage the website? Well, I will take that as a no, and we'll keep going. And what we have here in our next area here is I just try to position everything here as I'm setting up. What we'd like to do is no doubt share our intentions here from KCSA, Kelowna Citizen Safety Association. We've built some tools for you to be able to take on this in a very proactive, grassroots way. And the only way to really make this change is for people to activate, send the letters, bang the drums, really get involved and connect up with your community, connect up with your groups, share the information. And we've built some of those tools so you can do that. We also like to encourage you to sign petitions. We'd definitely encourage you to talk to your banks, finding out what they're prepared to do, what they're not doing, feed some of this information back. We do plan and hope to have further meetings to, keep it a space that we can all share in this knowledge, as that's doesn't seem to be really happening at this side of the fence, at the resident side of the fence. We're just getting disseminated information, usually from the top down or media approach, whether it be propaganda or not, doesn't matter. But it's whatever we get fed is some of it's very factual and it's great. And we can say that banks are lending, and yes, we can see that it's only really affecting the Richmond right now, but we also can sense what's happening ahead. We know this has already come to Kamloops. There's already several other claims across the country. This is not just a BC problem, although we're leading the charge with this problem. It's like a very horrible disease, as we like to say, as it's slowly making its way across to Eastern Canada. Obviously, Algonquins have got a problem with that. I think it's New Brunswick as well. Even Parliament House, Ottawa, is on unceded territory. We'd like to see how they're going to manage that one. So let's just say that we really do need to stamp this one, nut it out, because it doesn't work with an amendment, because any other challenges can still come up. It can take years for this to be resolved. In the meantime, industries and confidence has plummeted, and BC is going to suffer all over. We don't want to create hysteria where it's not needed, but clearly people are already feeling the rumblings. And as we can see and sense here, just in the conversations that we've already had, we don't really want to see industry. We don't want to see people and businesses leave British Columbia to further afield. I would say in a different province, but certainly, it could even be outside Canada if things get much worse. To say that, oh, well, this isn't the same problem for everyone, we do have something unusual being in an unceded territory. It is obviously the only province inside of Canada that is, which is making it worse for us. But what has happened with Undrip and an aspirational document that has now been enforced into law in Dripa in British Columbia is the first and only of its kind in the world. Now, as you can hear, I'm not from Canberra. I am Australian. And over the 10 to 15 odd years living in Australia, I can tell you I watched this unfold there in what they call The Voice. They didn't get it passed. It was actually turned down. Australians voted against it. But in doing so, they're now sort of chasing their own tail, and they're doing what we have done here for many years with treaties, which is what we should be residing in and relying back to. And now they're trying to enact treaties back in Australia and doing it, I would say, in the cover of darkness at the end of night and changing laws to push that through without people noticing. So they have a problem there. They have a problem in New Zealand. This is not a Canada problem. It's a worldwide problem, but BC has the worst part of it for enabling Dripa. So there is no other alternative truly but to repeal it. And that's what we're asking for all residents of BC, not just Kelowna. As far as what we can tell, nothing is happening in Kelowna. There is one point just for the residents here of Kelowna. There has been some discussion that we're in a stage 5 claim, so to speak. But when you look onto the treaties map, which we'll show you how very soon, it's not stage 5, it's stage 4 in conversation. People have actually seen it in stage 5, and now it does no longer represent what they'd seen. So I don't know if they're changing things in the background. But what all of this decision does do, it allows everybody to, in the back channels, to have, especially within the bans and the claims, start preparing themselves for when they're ready to make the claim. And you don't give someone the power and say, don't use it. So it's just a matter of time. So we really do need to activate and stamp this out. We can't be waiting for an amendment and, just because EB said, well, this is not the way we intended to use it. And we were sure that it wasn't going to happen in this light. He's made a lot of promises, and I'm not really sure that this wasn't exactly the way it was designed. So with that, I'd like to introduce our website and some of the tools. So I'm going to share some information with you now, if you can just bear with me. And like I say, this is all grassroots. I'm not a professional. I am a professional, but not in this light. I'm not a website builder. I'm just a resident that had to learn and teach ourselves how to do these things to help bring community together. We have got a website that we've created over the course of time since 2023. We've been doing a fair amount of what we call the environmental activist space and working with the City of Kelowna on very many different issues. If you want to look at some past projects on that, you can go to the past project side. You can see some of the town halls. We talk about the bills that I mentioned earlier, some of the actions, and of course, the postcard, which was actually helping with Bill 36 and getting the information out so we could try to support the doctors and stop the insanity of Bill 36. We spoke about that, as you can see, in a few different town halls, and we've had many Zoom meetings in the past. So if this speaks to you and you want to connect up, please go to your membership and donate button in the back. Just come down here. Tell us what it is under the section of what you're interested in. You can type in Undrip and we'll put you into connection for having Zoom meetings or newsletters about Undrip. If you've got other things you're interested in, just let us know and we will pop you into the right space. If you'd like to help out and you've got skill in helping us out, we would love to have you on board, just so you know. So just coming in from the start here, there is everywhere you can see Join KCSA today. We do have the latest information of what we're working on currently, which is why we have the Undrip Zoom advertised, and just the recent past that we had worked on. So that's a very clean space. You can learn about us and what sort of work that we do and what we're trying to do with keeping them accountable and protecting our rights, common sense policies and technology transparency, and I didn't say the right word. Some of the projects that we've initiated, and as of early December last year, where our steering committee has come together and decided on what sort of things we felt in our area was important to us, and Dripa is right up there with it, as is our council, municipality, working with them, alongside them, trying to have our voices heard, especially as we are advocates for safety in our town. This is certainly an area that if you feel that you find something and you're from Kelowna and it needs to be voiced, or you need support in something, please feel free to email us, just so you know, and we can try to maybe help you with tackling that as an issue for Kelowna Citizens Safety Association. We had very big success in a spraying program started from 2024, the BTK spray program, which went all over British Columbia. We got heavily involved and with a team with other people, scientists and medical professionals, looking at what was in the spray, and we put stakeholders together and worked as a team to absolutely have success at stopping it in West Kelowna. So we're very proud of that, and you know, BC Rising team, they've got a couple of the key personnel there that's helped getting the science behind it, and Lloyd gave the marketing and the media program to it. They banged the drum loud enough and advocated hard enough in Kelowna CSA for us to have stopped the 2025 program altogether. Now, there was 14, I think, towns across British Columbia that have been hit year after year. This is called spongy moth, or what they used to call gypsy moth. And it really is a very nefarious BTK spray, but 98% unknown ingredients. So we won't go there. That's another topic of discussion if you ever want to know anything about it. So we were going to be working about, you know, geoengineering, obviously what's going above our skies. The City Council does have a responsibility in our airspace to start holding some form of discussion and being accountable for what we're obviously inhaling. So this is something that's not a conspiratorial thing, not when you've got the government, US and the Senate's all addressing it, and you have different states in the US banning it. So I don't know where your political agenda lies on this, but this is something that we're not happy about, because once again, it's about safety and how we're living. EMF, Monitoring and Public Health Transparency Program, we'll be putting a team together with this. You can read about that another time, and if you want to get involved on that, please sign on up. Or if you happen to have an EMF reader, we'd love you on our team to help do some monitoring and base measurements. So where you can find the actions are on the Actions and Resources tool. Under here, we have just designed a few things, so you can go and have a play and have a look at a few things, but I'll just grab your eyes to a couple of areas. So what you can do is you can sign a petition. There's 4 of them in this particular document, of which I'll just quickly run through. And you can, oops. Okay. Apparently I didn't have it fully open. I need to fix this. We're still putting this website together at the last minute, just so you know. I don't know why that didn't load, but it didn't. So I need to fix that apparently. Okay. So the petition's designed just tells you a little bit about why and what it's about initially, and who's putting the effort of these campaigns together. All of these are active links. Of course, you've got One BC, Rebel News, Dripa is I don't know who's looking after that, but the biggest, of course, is the BC Conservative Party. I would say it'd be great to go in and sign all of them, cover all your bases, but let's hope the BC Conservatives actually do something with it. And coming back into here, we've got, you know, templates for members of the Legislative Assembly that you can just pick up and open to formulate it yourself. And once again, this is not doing what it's supposed to do. Yeah. But I'll get that cleaned up and just show you later anyways. So we have made some templates for your design. Put your name to, send it off to your MLA. You have a template for your actual MLA in your area. That's just another letter. I'm just seeing if all the links are working with this. Nope, definitely got issues. And we have an email address list for all the BC MLAs. We have the Find My MLA. If you're unsure who it is, you can find it and source it here. Scripts for calling, EB, MLA, and the city, your city where you live, or City of Kelowna for us, and make investigative questions and finding out what's going on with relation to land titles and things like that. As you can see, we do have a couple of flyers here, and this being one of them, you can print them off. We're going to have a 3-section of these DL cardstock flyers, so you can just print it off on one sheet. They are front and back. So on the front, it's just a conversation starter, as you can read. Are you okay with the following? Are you aware that under the current provincial policies, Indigenous landowners' claims could affect homes and properties in your area that you live? And did you know that the following Cowichan court decision concerns have been raised that unresolved Indigenous land title claims could affect mortgage renewals and lending security now and in the future? So if you've answered any of the questions that are yes to this, well, of course, you turn over the page and it actually, if I can get this up quick enough, it actually then tells you a little bit about Undrip, what is Dripa, the current situation, which we've just discussed this evening, what the issue is, why it's important to repeal, and obviously you can take some of these and you can scan the QR code or take some actionable steps. You can share this with others to obviously make some of this noise heard at the Legislative Assembly. Which is where we really want to get to and get rid of Dripa. We do have what we call an information sheet as well that's just coming along as we speak. I hopefully have got this one going, or it's a one page. I'm getting feedback here for some reason. I don't know why. Okay.
Yes.
Sorry about the delay on this one. Tells me I need permission to download. That's interesting. I thought I was permission. All right, I am going to go to the effort to find this for you. It's worthy. So this one's just been created, and it was going to be turned into a brochure, but instead we've just left it right now for a one-page, one-stop, all approach, where you can just print it off on an A4 and discuss it, hand it to people, QR coded. It's, again, got everything concise, and it's a little bit more of email sharing. It's a little bit more friendly. So I just wanted to show you that area as well. So sorry about the links on this. I'm not really sure what's happened. They worked before we got onto our webinar this evening, and I'm a bit amused as to why it's happening. But of course, we'll call it, some sort of googly got tech problem that we don't understand, but we will sort this out. The maps here this is the BC Treaties website, if it's going to be okay. Yes, awesome. This is what Tamara was talking about earlier. When you go to this section, you can actually look up your own area, wherever you are from. As you saw, we were from Kelowna, and I just need to get this zoomed out. You'll see that around Vancouver, there is something in the vicinity of about 40-odd tribes, bands, I think we call them here in Canada. I should get my wording right. And you'll see where they all are. A lot of it's in the Lower Mainland, Sunshine North, North Van. And here in Kelowna, this is our West Bank First Nations. If you click on it, you will see all the information that it is currently at stage 4, not currently negotiating. When you start playing around in this area, you'll find lots of really good information, especially for ones that have actually got claims on them, and they tell you the dates and what stages that they're at. So good to keep it abreast of where you are and what stages are happening in your area. So I will close it off on that one. As far as what we have, oh, and there's your Dripper Act, of course, I've got to mention that. As far as what we've done, we've been starting to send letters specifically to the members of Legislative Assembly, to David Eby in the City of Kelowna, because we are very interested in what they've got to say. We do plan on holding meetings with the RDCO, with West Kelowna Council, as well as our own. So these are the sorts of things that, although we are doing it here in Kelowna, we're trying to implore other people to do it. If you know of other groups that you can connect to that will connect with us, we can try to make this a bigger BC-wide initiative. Everyone's fractured and trying to do their own thing. We would love people to use the resources here, even in other groups. That's what it's for. We're not, not sharing our tools. If we've got it and making it, we can help you create your own group, if that be the case in your area, if you don't have one, to get you started. It's going to take, I think, that much for us to be successful, and we need to activate now, not waiting 18 months down the track when the damage is done. So the ask here again, I'm going to say very clearly is we really want you to participate in some form and some way that is comfortable for you. The easiest way is to obviously, if you're not wanting to be too active, is please sign, write the letters, send these things out, and share the information with people you know. A lot of people do not understand where we're at and the dangers that could be laying ahead of us. So to avoid it, we need to spread the word. On that, we're coming up to 9 o'clock here. It is just 9 now, and I promised you very well that we would shut at 9 and do the Zoom. But in the meantime, I would like to say that we appreciate you all being here, taking an interest, and certainly, enough to want to be able to know what the information's about. And hopefully we've imparted some of that for you this evening. And has anybody got any questions for us? And please let us know your ideas, your thoughts. Have you got anything you can contribute? We do need the help in any way, shape or form, and your great creative brains. So please come on in. We are looking at a media release, I forgot to mention as well. Lloyd is on the plan for that. And although we're still under construction, we are going to put a news area for all the latest information and all the links and resources for what's coming up, like the videos, like the documentation, things you can share that you can just go to. Under news and resources will be a library section. It's just that we only started this idea probably around the 15th of December, and we've had Christmas, New Year, and we're still trying to make it all happen. But I will tell you that we'll have it ready fully for you by the next time we meet in probably about a month. So please pop your details in the chat if you would like to be on the list and knowing when we do have more of these Zooms, or feel free to email or sign up on the website. And with that, if we don't have any questions, Lloyd, do you have anything you want to close off for this evening before we shut down on the Zoom?
Again, if you can help out, go to the website, put it in there, email us, whatever. We can use any help that we can get. We are appreciative of, and again, I thank you all for taking the time to come up to speed on this issue, and hopefully pass it around, let other people know to go to our website, and then we will try to do this again, and update on where everything's at, because there's still some questions that we need to find out about, especially with respect to industry. Very little comment coming out of them with respect to all of this. There's a bit from the Business Council and that, but very little. So there's lots of work to still do, and there's a lot of expertise here on this call as well. So anyway, I'll just leave it at that. And again, thanks everybody for coming out and finding about this new campaign that we're launching. And I think, Shane, did you want to say something there?
Yeah, I've got a question, Lloyd. Maybe I missed it in the presentation, but Christina Lowe and Gavin Dew, any engagement with them? I had a conversation with Christina Lowe just before Christmas, and she was adamant to how they were going to go to try to repeal Undrip and et cetera, et cetera, et cetera. But maybe Kelly's got some more insight there. I'm extremely frustrated with, the Conservative Party and all everything that's going on there. I will add one other thing. I think that what happened in Richmond is one of the best things to ever happen. And the reason I say that, I'm in the development industry, and I've been talking to a lot of people in the development industry, and I said that to them, and they said, why? And I'm like, because now people are paying attention. The minute that they think that their land could be in jeopardy, now they're actually paying attention.
Yeah.
So it's actually a bit of a blessing, believe it or not, because and this is just it'll fade away. That this story, as quick as it came, will disappear. So it's really important this group keeps it on the forefront. And there's a lot of people that are interested in this.
Yeah, very good comments, Shane. Thank you. We'd love to hear from you guys of people you want to hear from. We are talking about possibly holding a town hall, maybe having people just like Tom Issac or even, Bruce Hardy. These guys are fantastic in their knowledge. We want to hear from stakeholders locally or in BC of how it affects them. People like yourself, Shane, and in the industry, like Tamara, anyone who really feels that, they've got a story to tell as well. And what can we do to help bring awareness to that? Again, this is not just here for our Okanagan base, but it truly does need to go a lot wider. And hoping with the likes of, other groups in other towns and BC Rising initiative that we can spread that message a little further and start to create some unity amongst the fractured. So that's the intention. I'm hoping we're successful, but we're going to keep at it. We're going to have Zooms, like I say. This is the first one. We want to try and have them monthly if we can, which is why it's important if you want to be included in those Zooms to, reach out to us, connect to us, let us know that you want to have that invite. Again, either put your information in the chat or you sign up on the website. We do have a new email address called @proton.me. And we have been working around the clock 2 and 4 o'clock in the morning for the last few nights. So if we're not really on our best A game tonight, thank you for your grace, as we're all a little bit, I suppose, jagged around the edges here and just trying to make this, at least this initial conversation started. Things will get better and improve, that's for sure. Thank you so much, everybody, for attending. Thanks, Tamara. Thank you, Lloyd. Thank you, everybody, for doing great work and all your input. We really appreciate you.
Thank you, Tracy and Lloyd. This is incredible.
Yeah, thank you, Tamara.
Yeah,
Thanks,
thank
Tracy.
you to the
Thanks, Lloyd.
KCS team, the membership. We appreciate you and the steering committee for helping make this happen.